Right. Good afternoon, everyone. This is Eric Hauge at Homeline, and you're joining us on Wednesday, September 30th at 1:30 in the afternoon. And we're joined by Homeline's managing attorney and Tenant Hotline director, Mike Vra, for another weekly webinar series discussing tenant-landlord legal issues during the COVID-19 pandemic here in Minnesota. Just a reminder, Homeline is a statewide organization, nonprofit organization that provides free legal advice and confidential legal advice to renters throughout the state in English, Spanish, Somali, and Hmong languages. And we've advised over 250,000 renter households since we opened. We've been doing these seminars just about pretty much weekly since April. And since mid-April, and we're actually going to take a week off. Looking at coming up at next week, we'll be taking a week off, and the next webinar will be on Wednesday, October 14th. And then going forward, we may continue to do that on kind of an every other week basis, depending on the interest and what current topics are happening as far as eviction suspension and other related pandemic issues. So again, this week we will go through your questions that have been submitted in advance. Mike's going to just do a brief overview of where we're at currently and some new legal updates that have occurred in the past week. And then we'll take Q&A at the end. And then in the next seminar, again, we're skipping next week, and it'll be on October 14th. And we may have a guest speaker on that seminar. We'll send out information registration on that once we get that confirmed. And just a reminder, on our website, we've got recordings of all of our past webinars and a number of resources, FAQs, and general information about some of the more common topics that we hear about right now. So with that, I'm going to pass it over to Mike. Again, a reminder, we did get some questions in advance, but we're going to have plenty of time set aside today for questions, so feel free to submit them. All right, Mike.
Thanks, Eric. Hello, everyone. So again, as Eric just said, next week we're taking off. We have been doing this every week since mid-April. Back when we started mid-April, we were doing one every Wednesday and one every Thursday. The Wednesday sessions were devoted to tenants and social workers, people working on behalf of tenants. The Thursday sessions were devoted to landlords or property managers, and then we combined them into one. I can't remember when we did that, maybe June, but I've been doing weekly webinars since then. And we're just not sure how necessary it is to do these on a weekly basis if things don't change. If there is a radical change in the status of the rules, we'll certainly jump in and do one, but we're planning on doing them every couple of weeks now, probably with more guest speakers as well, as Eric mentioned. I know we have somebody lined up for the 28th that's going to be talking about all the evictions that have been filed since the pandemic began, and we're working through that. But October 14th will be our next official meeting that we have planned for a Wednesday webinar. So today we're going to talk about a couple of things before we get to questions. First, our standard, what are the hurdles that a landlord has to overcome to be able to file an eviction, along with a quick look at another lawsuit that's been filed by a group of landlords challenging something that the government's doing, this time a state order that the landlord group is challenging at this time. But let's start with our standard, what are the hurdles that a landlord has to get over in order to be able to file an eviction in Minnesota right now? And we're at the same point we're at since mid-March, frankly, in a lot of ways. The governor's moratorium through an executive order on evictions remains in place. That eviction moratorium is tied in time to the peacetime emergency declaration. So that was stated or declared in March of this year in response to COVID-19. It has been extended since then 6 times, the peacetime emergency. since June, since the extension in June, when the legislature was no longer in session, there have been automatic special sessions triggered by the 30-day increment renewal that the governor has given of the peacetime emergency. Since June, the legislature has had a chance to end the peacetime emergency. But in order to end the peacetime emergency, that Governor Walz has the power to continue to renew 30 days at a time. Both chambers of the Minnesota legislature would have to vote to end the peacetime emergency. Since June, the Senate, controlled by Republicans, they have the majority there, has voted to end the peacetime emergency. The House, controlled by the DFL, they have the majority there, has voted not to. And the governor obviously is a Democrat as well. And so that's where we're at. And we've been there since mid-March. There have been a couple tweaks to the governor's order when landlords could file some different reasons for filing evictions, despite the fact that there's a general moratorium on evictions. But for large part, landlords have not been able to file evictions against tenants since March in Minnesota. As we've mentioned dozens of times on these presentations, most evictions in Minnesota, well over 90%, are filed for non-payment of rent. So that is what evictions really are filed for, and those can't be filed at present. I'm not going to go through all the exceptions right now, but they're out there. And Eric can link up the most recent order, which is 20-79. If you're looking for executive orders, you just look up EO-20 for 2020. And then there's a list of them, and I think it's up to 89 executive orders. It's not just landlord tenant, it's not just the peacetime emergency, it's a lot of other things as well that have happened during 2020. So that is hurdle one that a landlord has to get past in order to be able to file an eviction in Minnesota. Hurdle number two, the CARES Act, which in large part expired the end of July, was federal legislation that was passed in March that stopped evictions from being filed for non-payment of rent only, specifically for non-payment of rent only, through July 25th, but it only affected landlords who were covered by the CARES Act, which is landlords that have any kind of government subsidy, or if they have a federally backed mortgage by Fannie Mae or Freddie Mac. And that was our best guess, 20 to 50% of landlords in Minnesota. I'm not sure we'll ever find out, because I don't know how much relevance it'll have. Although, look, the CARES Act does still have an impact, because if all the other moratoriums went away, the governor's moratorium went away, and that could go away October 12th. I mean, the legislature could vote to end it that day, or the governor could decide not to renew it. So it could end the state moratorium. The CDC order, which we'll talk about in a second, goes through the end of the year, the end of the calendar year. So let's just fast forward in time to say it's January 1, there's no Minnesota moratorium anymore, and the CDC order has expired on December 31 and it wasn't renewed. Could a landlord file an eviction on January 1st? Maybe. They might have to still give a 30-day notice requirement satisfaction under the CARES Act. So it might still play a role in when and if landlords can file an eviction. Well, not really if, but when. The last last hurdle that a landlord has to get past is that CDC order that I mentioned. Center for Disease Control is where this federal prohibition on evictions comes from. And Eric, if you could just scroll to the next screen. Thank you. Yeah, this went into effect earlier this month, and it goes through the end of the calendar year, New Year's Eve. It only works for non-payment of rent. So in Minnesota, the protections that are in place are much more expansive for tenants. A landlord can't file for almost certainly the second most common reason for evictions normally being filed in Minnesota is that a tenant has an extra person living with them, an extra adult. The boyfriend or the girlfriend has moved in, or their brother or sister, or somebody like that, an unauthorized occupant. A landlord cannot file an eviction in Minnesota because of the governor's moratorium for an unauthorized occupant at present. The CDC order, if the Minnesota moratorium went away, yeah, a landlord could file an eviction for an unauthorized occupant, or for having a dog when you're not supposed to, or a material breach of any other part of the lease other than non-payment of rent. The CDC order, though, has no effect in Minnesota, not currently, because there's more and a more expansive protection for tenants built into the state law. And the CDC order explicitly defers to a local order if it exists. And so it's not anything a tenant has to do to comply with. We still get questions about this on a daily basis from tenants because it's had a lot of press. This was, touted by the president through an executive order in August, which didn't really mean anything until this order went into effect on September 4th. And then suddenly, okay, there's a law that's been not passed, but stated, or a regulation, I should say, the CDC has. The CDC order, the Minnesota moratorium, the CARES Act, all of them say the rent is still due. It's a huge, important issue. I can certainly remember vividly all the contact we got from tenants in March and April saying that they were going to go on rent strike, or there was going to be a rent holiday, or rent was going to be canceled. That hasn't happened. I mean, tenants could go on a rent strike, I guess, but there's no law that says they get to do that without repercussions. Rent is still due. There's no rent holiday. Rent hasn't been canceled. Late fees are also allowed. This is really confusing for people as well. The CARES Act banned late fees for those places where a landlord was covered by the CARES Act. The state moratorium on evictions never banned late fees. The CDC order does not ban late fees. So we get a lot of contacts from tenants where a landlord has decided to start asking for late fees starting in August, and so we're wondering if that's legal. Yeah, it almost certainly is under the rules that we have. But again, the CDC order plays no meaningful role in Minnesota today, except for the fact that it's kind of a backstop, right? If the state moratorium went away, it's not like landlords could rush the courthouse and go file all their non-payment of rent evictions anyway. They'd have to wait through the end of the year based on this federal order. Okay, Eric, if you could go on to the next slide.
Can I ask you a question about late fees?
Sure.
Late fees. There is a state law on late fees, though, that limits them. And then, in addition to that, is at some point when this might lift, are late fees an evictable offense on non-payment of late fees?
I'm sorry. So all the moratorium gets lifted?
Yeah.
It might depend somewhat on the writing of the lease itself. Some leases say that not paying rent or not paying late fees is an evictable offense, or if the rent is late 3 times in a 12-month period, that it's an evictable offense. The truth is, landlords don't file evictions for reasons like that because they've probably been paid. And so they just want the money. That's really what they're looking for. This is one of the things that I talk about with landlord groups all the time when I give speeches to landlords exclusively, which is that landlords are not in the eviction business. They lose money on them. And so they only file them, at least smart landlords, the ones that are trying to make a go of it profit-wise, don't file evictions unless they've thought it through, and this is the only real recourse they think that they have, that they can do. So if a landlord got paid, so all the moratoriums go away, and then the landlord got paid all the rent that was due, are they going to go file an eviction because the tenant didn't pay their late fees on time? I mean, maybe they can, but it's not really a smart financial move for a landlord to do that. And so I think it's unlikely. You're going to have some landlords that are going to be furious because they think that tenants abuse this whole system, right? We've heard that from landlords that there's tenants out there that have the money, they're refusing to pay, and they're saying you can't do anything about it because of all this protection from the government. Okay. So maybe those landlords are going to be so angry that they're going to want to go file an eviction for any reason. I think it's much more likely that the landlord is going to say, all right, your lease is up. We're not going to renew your lease at that point, which I think would be a much more likely possibility. Although the market being what it is, we had Dan on from Housing Link about a month ago, I want to say, where he was talking about the market and how rents are actually going down. Vacancy rates are going up. It's hard to sort of predict how this all plays out eventually, but the moratoriums get lifted. Tenant settles up with the landlord. If they offer full rent but no late fees, I think you'd be hard pressed to find any landlord that's going to refuse that. That's a pretty good, if you have a tenant that didn't pay rent from March on, a landlord that got all the rent except the late fees. I mean, if I'm the tenant, I'm probably going to say, hey, look, I can give you all the rent, but I'm not going to give you any late fees. Take it or leave it. Let's put an agreement in writing. Most landlords are going to say, sure, where do I sign? Because that's going to be almost everything that's owed. And landlords might have been thinking they were never going to get that money anyway. So again, theoretically possible that a landlord could file an eviction for that. I'm just not sure how likely it is factually that a landlord really have a strong incentive to do that financially.
Sure. And then just to be clear, the other question was outside of these suspensions, there is a rule on how much a late fee can be in Minnesota.
Right. Yeah. No, there is a state law. It's been around since 2012, 2011. A landlord can't charge more than 8% of the rent that's due for late fees. So most landlords comply with this. I mean, we look at leases every day in our office. We talk to 15,000 renters a year in our tenant hotline. And so we see a lot of contracts. And we get asked about late fees a lot, but when you're glancing at a lease, even if somebody doesn't bring up the late fees, it's one of those things that your eye sort of gets drawn to. And most landlords follow this. I still think the most common late fee we see is $50, not 8% of the rent that's due. And the $50 is always much less than the 8% of the rent. There are still some landlords that'll have a daily late fee, $10 a day, $20 a day, $25 a day, that almost certainly don't work under the statute. But most landlords have decided to comply with this statute. They understand it. It's really kind of a clear rule. And they comply, because if I'm a landlord and I file an eviction and I have a giant late fee, it's going to be hard to explain if the judge challenges that part of the statute. I think it's a very likely result that the judge will award 0 late fees. They'll say something like, hey, look, landlord, I think you've been charging a illegal late fee probably to not just this tenant, but other tenants, so you're not going to get any late fees as part of this. And it's just a bad way to start a case as a landlord, having an illegal, unenforceable late fees clause as part of what you're asking the rent for in a non-payment case. It's one of those things that certainly in Hennepin and Ramsey County, it's going to catch the referee's eye if they see a massive late fee number. They're going to ask about it and wonder if it's legitimate. Doesn't mean the tenant wins the eviction. They might not have the rent money. But if it's a close call, that's going to hurt the landlord's argument on some level that they're asking for not allowed under the law late fee. So yeah, mentioned earlier that there's another court challenge. Our office just found out about it yesterday. It might have happened a while longer in the past than that. I'm not sure when this was filed exactly. And Eric might be able to get you a link to the court case itself. So this is a pair of Minnesota landlords suing the governor and the attorney general. That might be it. That might be all the people they're suing. I'm not sure about all the parties. It's hard to sometimes keep those all straight in your mind. And I just have read this case once or twice now. But the case is filed in, once again, federal district court, just like the case challenging the Minneapolis ordinances about tenant screening and security deposit caps that we talked about last week. Or a couple weeks ago. Anyhow, it's filed in federal district court representing a pair of Minnesota landlords. And the core of the case is challenging the governor's right or ability, power, however you want to phrase it, to have this eviction moratorium in place. So Eric found a list of cases somewhat similar to this. It changes from state to state because state law arguments thrown into these as well. So it really does matter which state you're in, honestly, which district you're in as well too. But like all these other cases that have been filed around the country, there's references to the several amendments to the Constitution, the contracts clause and due process and equal protection. I mean, it's this strange laundry list of supremacy clause. I can't remember if that's in this one or not. List of rationale why they think that the governor does not have the power to do this. To sum it up, it's a couple main concepts. The first one is an unlawful taking, that the governor is taking property of the landlord. And the property in this case would be rent and or the right to do whatever the landlord wishes to do with their property, is kind of what landlords are getting at with this argument. The other argument is that this should be the purview of the courts and or the legislature. I mean, the eviction statute itself is a legislative construct. The concept of evictions predates that statute by quite a bit in our legal history. And those have been the purview of the legislative and the judicial branches. Although the legislation is, of course, signed by the governor, unless it's veto proof or something like that. But those are the core arguments that the landlords are making. There are a lot of similarities to the arguments that we've talked about in recent cases where a landlord group was challenging the CDC order in Georgia. And like I mentioned, the Minnesota landlords challenging the Minneapolis ordinances about tenant screening and the security deposit cap. A lot of similarities as well with the landlord group that challenged the Minneapolis Section 8 ordinance that the Minnesota Supreme Court just a couple months ago ruled against landlords on. And so looking at the court case, my first impression was, well, why are they really filing this? I mean, we have the CDC order in place, right? And that goes through the end of the calendar year. Unless that gets either removed by the CDC or stricken by a court, that's our backstop. So a landlord, even if the landlords in Heights versus Waltz win their case and get a pretty quick injunction stopping Governor Waltz from enforcing this eviction moratorium, the CDC backstop is still there. So again, well over 9 out of 10 evictions that are filed in Minnesota for non-payment of rent. Those 9 out of 10 landlords still can't file an eviction. So who can still file an eviction? Well, it'd be this landlord's arguing that there's a breach of the contract that isn't covered by the exceptions in Governor Waltz's moratorium currently, which are on the extreme side for sure, right? If you seriously endanger others on the property or if you cause significant property damage, those are the types of exceptions that are built into the Governor Waltz moratorium. There's a more lax one, which is if the landlord personally or their family member is going to move in right away to the rental unit, then the landlord can bypass the moratorium then. As mentioned, we're going to be doing a sort of comprehensive analysis of eviction cases since the moratorium was started in March at the end of this month. The 28th is the day we're going to be doing that presentation. We got to gather a lot of statistics and data before we can do that, but we've already gotten a lot of it set up. But anyhow, does it make sense for landlords to file this case? I'm not really sure. I guess you can make the argument that, hey, look, the CDC order only goes through the end of December, which when it was passed in the beginning of September, that seemed like a long ways away. But maybe the governor is planning to renew this again and again and again. We don't know, right? The governor has renewed the eviction moratorium, the Minnesota-specific state moratorium, 6 times already. Now, as we talked about with Michael Dahl last week, the peacetime emergency is not just about evictions. In fact, if the eviction moratorium didn't exist, the state eviction moratorium didn't exist, and the governor decided today to institute that, everybody would look at it and wonder, why did the governor bother? Because we have the CDC order in place already. Now, the governor could do that, it seems like. So why would they bother? So it really is much less of a topic when it comes to, for instance, the special session where the legislature is talking about, should we eliminate the emergency powers or the peacetime emergency of Governor Waltz? They're not talking about evictions much right now because the CDC order is that backstop in place. So if you took it away, it still wouldn't stop, or it still wouldn't allow landlords to go file the evictions. So again, I'm not sure, even if the landlords win this case, which I think is a long shot. I looked at, between 6 and 10 cases from around the country that have been filed that have been similar to these claims. The language wasn't exactly the same in the complaint that the lawyers for the landlords filed, but it was very similar in a lot of ways. The arguments were certainly similar. And I haven't seen any where the landlords have won. All the decisions I've seen, the courts have been saying, no, the governor has the power to do this. That's just how it is. And so I can't say that I'm surprised that somebody filed this case. I would have thought landlord groups would have filed this case a long time ago, honestly. It would have made a lot more sense strategically based on what other rules we have for a landlord group to have filed this in June or July or even the beginning of August when the CARES Act was clearly no longer as entrenched. And so that's a brief introduction to this new court challenge to one of the eviction moratorium that we're dealing with. As mentioned, even if this is a successful challenge, I'm not sure how much of an impact it really has in the landlord-tenant landscape, because 9 out of 10 evictions, landlords still aren't going to be able to file, at least until the end of the calendar year. Wow, was that almost a half an hour that I went on? Okay. Yeah, I think that's it for the summary of where we are at today. Happy to dive into the questions. I think we had some submitted in advance first, Eric, is that right?
Yeah, there's a couple that have been submitted already. So, and again, we have plenty of time. So if there's any more questions, go ahead and send them in over the chat or the Q&A. Excuse me. James submitted a question. Sounds like James is a landlord, has a tenant on Section 8. They completed a 1-year lease at the end of May and do not want to renew the lease and want the tenant to vacate.
Well, okay, so James is asking all the questions about the hurdles that we've been talking about. And so the governor's moratorium on evictions, look, I tossed around the word eviction a lot, and I don't always define it. Maybe I should each time. But an eviction is a court case. An eviction is a court case where the landlord says, Judge, you've got to remove this tenant. We also refer to them as unlawful detainers or UDs. But and tenants will throw these words around too, by the way. They'll call up our hotline, say, I'm being evicted. And that means a lot of things to a lot of different people. And so one of the things we ask about is there a court date? Did the landlord file a court case? And then we know that an eviction's been filed, an actual court case. The governor's moratorium doesn't just stop evictions, those court cases, from being filed. It also says that a tenancy cannot be terminated by a landlord, which wasn't clear in the original orders from the governor. There have been two substantial tweaks to the eviction moratorium, and one of the tweaks changed the wording, so we now know that a notice to vacate, a notice to quit, a notice of non-renewal, none of those are legal under the governor's order. And so that is not something that a landlord could do at this point. The lease ended the end of May. And so I assume James has been continuing to accept rent from this tenant since then. Probably what they have at this point is, I'm guessing, it's hard to know without seeing the actual lease, is a month-to-month lease. If the rent is due on the first of each month, that's probably what we have. That goes on in perpetuity unless and until somebody gives a proper notice. As mentioned, a landlord can't give proper notice under the eviction moratorium rules that the governor has in place. Now, the CDC order doesn't stop that. The CARES Act order wouldn't stop it, although a 30-day notice might be required. James is one of those people that the governor's order would matter if it was removed, but it's not removed right now. So no, a landlord in James's situation cannot simply make the tenant go. I mean, you can ask, I guess, but if the tenant refuses, there's not much more you can do right now.
All right, and I guess another point to make on this one too is they did specify the tenant has Section 8, so this would be a situation where, you know, you likely are getting at least the housing authority's payment, and if the tenant's lost income, you know, Section 8 voucher the rent amount will change for the tenant. So a situation where rent likely is coming in, but
right, it is like, I mean, we've actually talked to landlords that are suddenly much more interested in getting Section 8 tenants. So if James doesn't want the Section 8 tenant, there might be a landlord out there who really does, because of what you just talked about, Eric, that there's more of a certainty that a landlord is going to get paid a large percentage of their rent, and maybe all the rent from the federal government. That's how the Section 8 program works. The tenant pays 30% of their income for rent, and the rest is paid by Uncle Sam. And so, yeah, there are landlords that would prefer a Section 8 tenant right now. Yeah.
All right. So another question. Abby asks, can a trashed apartment that is severely dirty and possibly possibly has an infestation of bugs be a health and safety issue for possible eviction?
Short answer is maybe, Abby. I mean, what we're looking at in the governor's order is the only one that fits close to what you're talking about is that the tenant has caused significant damage to the property. which I believe, I don't have the order right in front of me, but I believe it is past tense. So I guess it could be ongoing. You could make the argument that it is past tense and present tense, likely to be future tense. But no, you as a landlord have to be able to show significant property damage. And so I get the question. It's going to be probably a very fact-specific answers going forward. There's not much to go on about the facts from what you've said there. Based on what's in front of me, what you wrote, I would bet against a landlord filing an eviction for that reason. I just don't know that it's enough to win that argument. But I mean, a landlord could try it, although it costs $300 to file an eviction. And like I say, I just don't think it's a sure thing. I take it back. It's not past tense. It says significantly damages property. So that's an odd tense. I guess it means anytime. So yeah, the time frame part isn't that critical. I think it is important, by the way. We've had to look this up several times, where a landlord already lives in the property and they're trying to chase a tenant out by saying, hey, I'm going to take possession of the property. And I don't think a landlord can do that. I think they have to have not had possession. This is the rule where the landlord or their family member could take possession of the place. But it talks about, that part of the order talks about the need to move into, which implies that the landlord isn't currently there. So there you go.
Right. So let's see here. We have a couple other questions that have come in. So here's, a question jumping back to the CARES Act. What dates did the CARES Act prevent late fees? If a landlord charged those fees, how can a tenant dispute the fees and the interest on those fees?
So I think the right reading of when the CARES Act late fees stopped mattering would be July 25th. So any late fees that a landlord charged between late March and the end of July, again, if and only if the landlord is covered by the CARES Act, which in some cases it's easy to figure out. It's a giant building and there's a massive public subsidy. Okay, the CARES Act is going to apply there. But if it's a duplex or a 4-unit building, maybe the CARES Act applies. And so that's the first question a tenant's got to be able to try to figure out the answer to. And that's not easy to figure that out, because it's I'm not going to say it's unknowable, but it's really difficult to know whether or not that landlord is covered by the CARES Act. But July 25th is the day that it would be allowed for a landlord to do that.
Right. And then, one second here. James asked maybe a follow-up on the first question. Tenant does not live in the house. So the first question was the tenant with Section 8, and the 1-year lease ended in May. They don't want to renew. So tenant does not live in the house, is staying with a boyfriend, has a drug conviction, and children moved, behind $600 in rent, leaves lights on, inspected home with proper notice, and smoke detectors had been disabled.
So clearly a landlord, and I guess, and if you don't mind just sort of talking this one through with me, Eric, that he wants to evict.
Wants to non-renew.
The boyfriend or the girl? I'm not sure.
Well, I mean, it sounds. Yeah,
because it's she that he's referring to throughout the question.
Right.
So I'm not sure who the tenant is, I guess, in my mind. She does not live in the house, stays. Oh, she's kind of abandoned the place is what I think he's saying.
I think so. Yep.
Although,
yeah, I mean, it's not clear.
Yeah. Oh, and then he's got a follow-up question as well. She's on Section 8. If we give her 60 days notice, can we have her pay her own utilities? We gave her notice. We're not renewing her lease. Well, the first thing I'd say here, James, is that not renewing her lease might be a violation of the governor's order, is the short first thought that comes to mind. Okay, you say she has a drug conviction in July. That doesn't mean that you can evict her for anything in the governor's list. If there were drugs, illegal drugs possessed in the property, maybe you'd have an argument for that. Under 504B 171, which is a specific statute that's been an exception since March in the governor's moratorium on evictions, that if there are drugs possessed in the home, there's some other things covered by that statute, but drugs possessed in the home, then you might be able to file an eviction for that purpose. But short of that, it's not an easy case for me to tell you, yeah, you're going to win if this goes on. And the fact that you simply gave a notice to vacate might be a violation of the governor's order, is the short answer. The smoke detectors part, is that significantly damaging the property? I guess maybe. Or seriously endangering others. Maybe it's doing that. It might be seriously endangering the property if there's nobody else living and it's a single family home. Not sure. But anyhow, yeah, I can't make you a guarantee that you'd win that case. And I am slightly concerned that the mere fact that a notice to vacate was given might be a violation of the governor's order. Yeah.
All right. A couple other questions come in. If people keep saying housing is a human right, why doesn't the Minnesota Department of Human Rights get involved in standing up for renters who should have some expectation to remain in their homes? Yeah, so this is kind of a borderline philosophical question. It's not really the world I work in. I work in the world of what's referred to as black letter law. What's in the rules? What do the laws say? And when it comes to something like discrimination, the real question you have to ask is, okay, is this a protected class? That's really what you have to ask to figure out if fair housing / discrimination rules apply. And those classes, protected classes, are very uncommon, actually. I mean, all of us fit into, 1,000 stereotypical classes, if you want to think of it that way, right? But most of them are not protected classes. Now, some of them are. Some of them are protected all the way up to the federal level, like race and religion and things like that. Some rules are protected by state laws. Some are even county or city laws. But not everything is a protected class. So, for instance, landlords that say, when they do screening, I don't want to rent to you because you have bad credit. Okay, so you could say that people with bad credit is a class of people, right? You could just lump them all together as a group and say anybody with a credit score under 600 is somebody with bad credit, or 550, or whatever number you want to use. Is that a protected class, is the question from a discrimination standpoint. And at present, it is not a protected class. It just isn't. And so, well, you could go file a discrimination suit as a tenant or applicant trying to get housing with bad credit and say, hey, this is unfair. I had bad credit. The landlord turned me down because of my bad credit. Doesn't mean the tenant's going to win that argument. In fact, if they filed a complaint with the Department of Human Rights, which is a state agency, Minneapolis and St. Paul have their own versions as well. They should say, sorry, understand that, that you feel like this is unfair, but it's not a protected class. And so housing, being declared a human right, is something that a lot of people have on the tip of their tongues or their minds. It's not like I disagree with that concept. It's just that as an attorney, what I look at is, okay, what footing does somebody have legally to make that assertion? And at present, housing is not something that fits into that protected class status. That doesn't mean it won't be. Many of our protected classes weren't protected classes until they were, right? In fact, that's pretty much all of them weren't protected classes until they were. And so I'm not saying that the march of time won't eventually make housing a human right on some level, but it's not in the same class as race and religion, receipt of public assistance in Minnesota, sexual orientation. It just isn't on that same level yet.
Maybe someday it will be, but that takes political will, whether it's from a legislative body or through a court, I guess.
All right. And let's see here. The next question is from a tenant. What constitutes harassment by my landlord? He called me and hung up a few times before 8 a.m., dumped dead raccoons under my kitchen window in the past, and has been vocal about getting out of his property. I'm fearful of holding over, afraid of what he will do in response to me staying longer than agreed upon, but also currently have no place to go. I'm afraid he'll assault me or worse. Who do I call? What do I do about this?
Well, as far as who do I call, it's on the screen. You can call our Tenant Hotline. We're a free service. And we'll talk through all the details of what you're going through. This is literally the kind of stuff we do. We walk people through really complicated situations, and we talk about whatever laws might apply. We also talk about what laws don't apply, right? If the law won't protect the tenant, we'll talk about that. In your general situation, it sounds like you've got a lease that's coming up. The landlord's trying to make you go, but you don't have a place to go. The governor's moratorium on evictions might protect you. And it's not just us saying that. It's not just the governor saying that. It's also the Minnesota Attorney General who would be enforcing that if the landlord tries to push on this. So, and they do enforce this. We had Assistant Attorney General Catherine Kelly on for one of our webinars, and she talked about the volume of cases that they've been working on, and that they are explaining this to landlords. And almost every landlord says, okay, if that's the rule, I'll follow it. Once they get that call from the Minnesota Attorney General, it really does have an impact on people. When somebody from the AG's office calls you up and says, hey, I think you're violating a law, you got to do this. Most people will say, okay, I'll comply. I understand. That kind of name still has quite an impact on people when they pick up their phone, and it's the AG's office on the other side.
Right, yeah, and I put up our hotline number and the AG's, hotline numbers on the screen, and then the Attorney General's contact info, including their eviction complaint form, is in the chat there.
Right, and if that tenant were to call us, the one that just submitted the thing with the dead raccoons and stuff like that, we might be telling her, hey, the AG's office is the one place that can really matter here, but there's a lot of other details. Honestly, we really would want somebody like that in that situation to give us a call. We'll walk through it. And also email our office for free. You can email one of the attorneys, and we'll get back to you as soon as we can with an answer about the situation.
All right. Jumping back, James is following up on his question about the tenant who had given a non-renewal to. Can we give a 60 days notice to put utilities in the tenant's name?
So that's a different question that James is asking here. Sort of looking for some way to pressure the tenant to get out, I'm guessing. And making the cost higher is one way to do that, I guess. I would argue that that is in fact another termination of the lease. So we've talked about this before, but I don't mind bringing it up. A lease contract, if you think about what constitutes a lease, there's a few key elements to it. One is, there's only four. There's the parties, right? Who the landlord, who the tenant is. There's the length of time. Is it month to month? Is it 1 year? There's the property itself, right? So what's the address? And then there's the cost. I've looked at leases that are literally 50 pages long, but they really come down to those four things. Now, landlords can have a whole bunch of other laws or rules in them, and that's what they are. They're landlord rules. But a basic lease has those four things in it. Who are the parties? What's the address? How long is it for? What does it cost? Now, if you decide to switch over from the utilities being in the landlord's name to the tenant's name, then you're effectively changing one of those four pillars, the what does it cost pillar. So you're terminating that earlier lease and replacing it with a new lease that has a higher price. It's not necessarily rent out of pocket, but the tenant would owe this. I mean, if I'm in this kind of situation, one of the things I might do as a landlord is say, hey, look, tenant, I can't a bunch of money, but let's start with this. Can you just turn the lights off? You leave them on all the time and you don't even seem to be home. I'm not sure if you're near there, but you could say something like, I'll keep an eye on the property. I'll help keep an eye out for it. I can't tell from your questions. It sounds like maybe you are nearby. But anyhow, that is, I think, terminating the tenancy by changing the rental amount. So I think it might still be a violation of the governor's order, the moratorium on evictions.
And I'm just putting in the chat the information about Minnesota Housing's COVID-19 Housing Assistance Program, which we've spoken about in previous sessions and had staff from the agency on to talk through it. There is a caveat to that, that tenants that it is tenants that have to apply for that program. And also if you're a tenant that has an income, a subsidy that alters the amount of rent due based on your income, you may not be eligible. But my understanding is you can still be eligible for utility payments. So that's an option for tenants who are either behind on rent or also, like, I mean, obviously maybe not this situation, but just highlighting the fact that there are some resources out there for tenants who might be behind on both rent and utility payments.
And let me jump in and remind people that if you have a question, landlord-tenant law, we've got fairly open phone lines right now, or chat lines or Q&A lines. And so we'll be happy to try to answer whatever you have. We still have almost 45 minutes left, and I know we have a couple questions in line, but if you have a question, please feel free to answer it or ask it. As you've heard, if you've watched any of these past webinars or today, I can speak for a long time if necessary. And I'd rather not filibuster. I'd rather get to question after question after question, or we can end early, which is fine too. But if you have a question and you want to ask it, you'll get in quickly, and hopefully you'll get an answer that will be something you can use.
Yeah, so another one that was submitted here. Is there any guidance pertaining to property abandonment during this time? The tenant lives in permanent supportive housing with case management, has not been living in the home in months, and will not meet with the landlord or case manager.
So first of all, there's no new rules about property abandonment now in COVID-19. There's been nothing declared that I've seen anywhere, certainly not in the governor's orders, about what constitutes property abandonment right now. In normal times, pre-COVID-19, if I were a landlord lawyer, which of course I'm not, I'm a tenant attorney, but if I were a landlord lawyer and I had a landlord who suspected that a tenant had moved out, I might be really cautiously saying you should go file an eviction to the landlord, to the owner. Because otherwise, the alternative is if you throw somebody's stuff out, you change the locks, there's all kinds of penalties you might face. In COVID-19, that option of filing the eviction, that's just not really viable for a landlord. So it's difficult to do. I mean, you can do all the same things that landlords did pre-COVID-19, which is you try to reach the tenant. Hey, you know what, tenant, we're going to swing by in 3 days wearing all the PPE we can find, but we just need to confirm that you're still present. You haven't responded to our questions, and so we want to make sure that everything's okay and that you're still there. And then when you go in, you bring more than one person, you video it as you come, knock, announce before you go through every single door. Before you go through any of the bedroom doors or the bathroom doors, you knock and announce who you are, because obviously nobody wants to walk in and find the tenant asleep or in the shower or something like that. That's a terrible spot for everybody. But there's not really any special new rules about the property abandonment. That's the same kind of advice I used to give whenever a landlord would ask me that kind of question at a speech. How do I determine that a place has been abandoned? Certainly, modern technology, you want to send emails, texts, regular US mail letters, phone calls, every kind of contact you can make to try to connect with the tenant to confirm that they're leaving. If they want to be gone, great. Just let us know that you want to be gone so we can move on and have somebody else move in that might need the place. But yeah, there's no special new rules under COVID-19 for that.
All right. Question from other participant, Gabrielle. Are there programs or other programs other than county emergency assistance for assistance with past due rental payments for those with subsidized housing or the subsidy changes with income?
I'll let you answer that one, Eric. That's more in your world than mine.
Yeah. So again, what I was discussing was the Minnesota Housing CHAP, or COVID-19 Housing Assistance Program. That's the $100 million that's of CARES Act funding that the governor set aside to Minnesota Housing, and the info is in the chat. You call 211 or apply online. They go through the initial process of identifying if you're eligible, and then you get referred to a local administrator based on where you are in the state. And that's the one that's got this exception for folks that are on those rental subsidies. And I'm not sure about, so county assistance is different. I think, Hennepin and Ramsey and some other counties have also put aside some of their CARES Act COVID funding to rental assistance. And so I'm not sure if those have the same restrictions that the state program did. The other place where we've been advising folks to go is just simply 211 in general, because if they're unable to apply or get resources through the chat program, there might be other local resources that are available. So for example, on our COVID-19 page, we have a small list of some of the community action agency type organizations that in some cases have their own local pots of funding that have come from private foundations, or in some cases city governments. And so some examples of that is VEEP, Volunteers Enlisted, I forget what they stand for, Volunteers Enlisted to Assist People, I think. They have, I think, received funding from multiple cities that in their service area. Bloomington, I think Richfield, there might be others in the South Metro. And then STEP in St. Louis Park. So that's always the other suggestion, is look to see if there's something locally. Some of those programs might have assistance available. And I think, there was I think there was this article recently about that program, and one of the questions was about, somebody asked the question to, I think a Minnesota Housing staff person about that, and their answer was something to I think the effect of that those income-based programs should in a lot of cases drop people's rents if they lack income by quite a bit, if not to zero. That's not true in all cases. There are subsidy programs that have minimum rent requirements, even if they're entirely income-based. So there is going to be a gap there sometimes. And so, seek elsewhere. And like I said, on our COVID page, which I'll put the link up again, we have a list of some of those. We don't have them all throughout the state, but that's another place where 211 might be able to help. Okay, James just follows up saying, feels like our house is being held hostage with the tenant who discussed earlier.
Yeah, so James's tenant was, again, she wasn't in possession much. She left the lights on, and he can't non-renew her, was my assessment, and probably can't add on a utility charge as well. And James, look, I know that landlords are feeling frustrated by all of this. I get that. I absolutely do. And I'm not sure what the easy answer is. I have a sense why the governor passed the moratorium originally, which was we don't want people needing to move around, and we don't want people losing their home because they lost a job that they didn't deserve to lose, all right? It wasn't like they didn't show up for work. They were happy to continue their job, but the job was lost. But landlords are stuck with a lot of this fact. And I'm not entirely sure why you want the tenant gone. It sounds like, she's just disappeared, but I think that she hasn't paid her rent. I'm not sure how frustrated you'd be if the rent was current. But there are these programs out there where, there is some money that eventually goes to the landlord, and Eric was just talking about them, to catch up on what rent might be due. But no, I understand. It is a frustrating time for a lot of people, and landlords certainly have a right to complain about it. But at this point, all we're trying to do is make sure everybody hopefully understands what the rules are. I'm not writing them. And I certainly didn't write or have any impact on the CDC rule, which will go through the end of the year. That was the well, it's not even the federal government, it's the president's administration that did that.
Yeah, and I just pulled up that, I put the link to where on our page there are some of those resources. So yeah, like for example, Veep has gotten some funding from some South Metro cities, STEP in St. Louis Park, CEAP, CEAP. They have some housing assistance for sort of the Northwest Metro, Hennepin County. So there are some of those available. All right, another question that's come in from Kim. I've received,
oh, hey, Kim.
Kim's received the abandonment question, property abandonment question a lot. Start with the question of whether any keys were returned or left behind. An affirmative, yes, I left is best. Did they take anything with them? We'll try to track down the person. As you said, it's a tough spot to be in.
So Kim Tennyson is the person who submitted this. Kim was one of our guest speakers and has been a frequent commenter and watches. And hello, Kim, again. Thanks for chiming in. Kim is a landlord attorney, and we had her on as a guest. And we might do that again at some point if she's willing to come back on. Anyhow, she's referring back to that abandonment question that we talked about. Look, if the tenant gives up the keys mean a lot in landlord-tenant world. Judges really look at keys as being significant. They care about that when it comes to whether a boyfriend has moved in with a girlfriend. Does the boyfriend have the keys or not? That matters a lot. If the landlord is arguing that the tenant has abandoned the place and the tenant actually returned the keys, yeah, I'm with Kim. That's a big boost for the landlord's argument that the place has been abandoned. I think it's a really tough argument for the tenant to say, yeah, I turned in the keys, but I didn't abandon the place. That's a stretch legally. I mean, I guess I can think up a fact pattern or two like that, but it's not easy. Yeah, the other kinds of questions would be, did they take the stuff of value? If they left behind a lot of things that look like they're super valuable to them, then chances are they either haven't abandoned the place or they had to go in a hurry, like they got, hauled to jail or something like that, which, it happens. And Kim says, I would try to track down the person as much as you can, of course. I give one last piece of advice on this, which is this. Let's say the landlord has decided that the place has been abandoned. It's been months. The tenant won't return calls. It looks like they took some of the valuable stuff. And you look through their stuff before you throw it out. You wait the time that you need to throw the property away. And you look through their stuff and you find a birth certificate and maybe an album of baby pictures. That's not the same thing as a cat urine soaked couch, right? I mean, those types of small, almost irreplaceable things might be worth putting in a box and just storing them somewhere in your office. The tenant someday might want them back. And while it won't cost you much of anything to store them, it might stop a tenant from someday saying, hey, I didn't abandon the property, I'm going to sue you, if you actually have those ultra personally, sentimentally valuable or difficult to replace items that are small stored. So it's not advice that you'll find anywhere in a statute or in a case. It's I guess, I don't even really think of it as lawyer advice, it's kind of human advice, that's one way to diffuse that situation if it becomes a problem later on. Sure, I've dealt with plenty of tenants over the years that say, hey, my landlord came in, I hadn't left yet, and they took all this stuff and it was worth tens of thousands of dollars. Yes, we've had those cases. But the cases where tenants are more upset are where they lose the baby photos or the kid's teddy bear from, that they'd held on to for 20 years or whatever. And so those sentimental things can mean more to a tenant than the actual marginally valuable things are certainly the valuable things too.
All right. Well, thanks, Kim, for chiming in on that one. Another question. Do you know of any larger or smaller apartments that have COVID outbreaks where the spread occurs from shared spaces?
I have not heard that. Have you?
I don't think so. I mean, we do get, ever since the beginning, we have gotten a lot of calls, an increased number of calls sort of about privacy issues in people's personal unit, in their actual unit. And I guess some questions also about sort of public amenities and or common areas, spaces and amenities that have been shut down or limited access. But I'm not sure if we've necessarily heard of any notable sort of outbreaks in apartment buildings.
Yeah, and I think it'd be hard to necessarily trace it to the lobby where the mailboxes are. How can you show that tenant contracted the COVID-19 from that? And if the tenant has never left their unit except for that since COVID-19 happened, I guess maybe they'd have an argument. But if they've gone to the store, they've gone out for a walk or whatever, to actually be able to somehow pin that back on the landlord would be tricky. And I'm not even sure if that's what the question is really asking. The mask mandate from the governor is not that old. It's only been around for maybe a couple months now. That requires in those common areas that people are wearing masks as well. So it's a question that we do get a fair amount of is, hey, how do I make my landlord make my neighbors wear masks in the common areas of the building, because they don't seem to care about that. We get that somewhat regularly right now. And it's not easy. I mean, I think a tenant could maybe file a rent escrow to try to force their landlord to enforce the governor's order. I think that the tenant could call the attorney general's office and complain about this as well. But thankfully, we haven't heard a lot of this. We have heard, and I see the follow-up question, I think it's from the same person, the landlord learns of positive cases, are they required or should they inform other tenants? Yeah, that's there's a lot of competing issues there. Does the landlord have a responsibility to inform other tenants that there are positive cases in the building? I don't know that there's a legal or duty for the landlord to do that. I don't think there's any limit on it either. I think if a landlord decided they wanted to inform neighboring tenants about somebody in the building has COVID-19, I mean, look, a landlord is not the same as a doctor or a lawyer or a clergy member. They have no duty of confidentiality built into their title. I think it's terrible business practice for landlords to talk about the finances of the neighbors with another neighbor. But it's not like I said, they're not a lawyer or a doctor or a clergy member. They have no legally recognized duty of confidentiality. And so there are all kinds of concerns about this, but is there a requirement that the landlord informs neighbors about COVID? I don't think so. Is it a good idea? The larger the building, I think the more insulated the landlord is if they decide to tell people about it. Because if they say, hey, look, I'm not going to name names, but we've had 2 reports of COVID-19 positive tests in this building. Everybody needs to be masked up. Everybody needs to be careful. And we're going to limit these spaces. You know, we're only going to let you go to the mailbox if your last name is, you know, R through Z from these hours, whatever they might want to do to try to curb things. I'm not sure if that's a good solution or not, but I don't think that there's a law that requires them to do it. And I don't think there's a law that says that they can't do that either, is the long answer, I guess.
All right. Even if the governor lifts the moratorium, the state Minnesota moratorium, because of the CDC, we will still not be able to evict. Yeah, so, and we talked about this before, and I don't mind talking about it again. Honestly, it's one of the reasons why we do this session and have done this session since mid-April, is this is confusing stuff. If the governor lifts the state moratorium for non-payment of rent cases in Minnesota, a landlord still couldn't file an eviction until the end of December because of that CDC order. That's right. That is the federal backstop that's there. So if you hear some state senator or state representative railing against the governor to end the eviction moratorium, and honestly, it's something I've seen in the media. I've noticed in a couple articles where they talk recently, after the CDC moratorium is in place, about the governor's moratorium somehow being the one thing that's stopping landlords from filing an eviction. It's just not the case right now. I mean, there's more than one hurdle that the landlord has to get past to get to the eviction finish line. Yeah, so just reading through some that have been submitted here. Add Kim's comment here. Kim says she always advises that a landlord not actually throw away things that might seem valuable, such as personal documents and photos. You're right, Mike. It's the stuff the tenant can't replace and will be more, and they might be more likely to pursue legal action. Again, on abandoned property.
Yeah, no, thanks for that sort of seconding of that concept, Kim. It's one of those things that I've said to landlord groups since I've started this line of work, and I really believe that that's the stuff that people call us about when they're saying, "Hey, this is what I lost," and I ask for a list of what they lost or a description, and they'll always start with the stuff that most of us would consider irreplaceable. Yeah.
Right. And so a follow-up kind of from the COVID test questions. Should or does a tenant have an obligation to disclose that they have a positive COVID test to the landlord or other tenants? I think you kind of answered that a little bit.
I don't think so. I don't think a tenant has an obligation under the law to disclose that to their landlord or to other tenants. I mean, they could, and many people would in that situation, but is there a legal obligation? I don't know of any.
Yep. And then another question on this: can a landlord limit a tenant's guests due to COVID?
Yeah, and I'm looking at the question. Actually, you omitted a word. Can a landlord still limit a tenant's guests due to COVID? I'm not sure that they ever could. Not much. I mean, there are limitations on the number of people that can gather together. I think there's still one of those limitations in Minnesota. It's honestly hard to follow all those things. I feel for people that ask questions about this stuff, because the stuff that we know, landlord-tenant specific issues, are still confusing and complicated and hard to follow. But on the general stuff, like which restaurants are allowed to be open, how open can they be, how many people can you have in one gathering, I don't follow it that closely because it just doesn't impact the kind of work that I do that much. So I think it's something like a 250 person limitation on an indoor gathering at present. I want to say, I might be wrong about that, but you still have to have social distancing separation. I don't think that's going to really apply to the question that I have in front of us. Can a landlord still limit a tenant's guests due to COVID? But it is something we actually did see a lot of, especially at the outset of all this, where landlords were saying, you know what, no guests. Don't care. You can't have a guest. We need to stop COVID, and so I'm not going to allow any guests to come in. But the tenant still had their regular rights, and those regular rights include the right to have guests, to have visitors come over to their place if they were invited. And so was that legal? There was an argument at one point that you could have made that it would be a non-essential trip for a guest to come over, depending on why they were going. If they were delivering groceries or medicine or something like that, then probably there would have been an exception. But I don't think that all guests could ever have been or excluded in some sort of blanket rule under any of the orders that we ever had. So this implication that a landlord did have the right to limit all the guests that a tenant could have, I'm not sure that that's correct. I think the governor's orders might have been able to limit that, but a landlord unilaterally saying, I'm going to limit guests, I'm not sure that they've had that power unless it was built into their lease. It's actually, wow, this would have been 15, 20 years ago. There was an apartment building in Bloomington that wanted to, they had a lot of crime in their building, and they were trying to deal with it, and the landlord just decided they were fed up. Big building, a couple hundred units. And the landlord just decided, this was sort of Berlin Wall-like, where one day there's no wall and the next day there's a wall. The landlord said, no more guests. You can't have a guest unless you run them by me. I got to know who they are. I got to see who they are. I got to approve them before you can have the guest. Big problem the landlord had was this was in the middle of everybody's lease. Just right in the middle of everybody's lease, right? It was like November, and most of the leases are from the summer to the summer, like it still is. And so the landlord just unilaterally instituted this rule saying no more guests. That didn't last long. It actually got a lot of media. But could a landlord do that from the beginning of a lease going forward? I guess. I mean, the only types of places that I really see that occurring are usually domestic abuse type shelters, where they're really strictly limiting any guests at all and practically forbidding all of them. And they're probably regulated by different rules than landlord-tenant rules. But if a landlord wanted to go with a no guest policy, unless approved by the landlord, or no guest policy at all, it's got to be in the lease to start. And I'm not sure how many takers you're going to get. I know the market is still tight, and I know people still need a place to live, but I'm not sure people are going to want to live in a place where they're not allowed to have guests. And so if it's in the lease and you're trying to convince a tenant to sign a lease with that in there, there's going to be a decent percentage of tenants that are going to say, that's really one of your rules? I'm not going to take the place. And look, I know we're in a different world right now because of COVID, but yeah, I don't think that a landlord really has much power to limit a tenant's guests due to COVID any longer. The best traction they had was the argument earlier in the pandemic where people were traveling from place to place, and that might have been non-essential. And so they could have called the authorities at that point. But a landlord, I'm not sure, being able to evict or something because somebody has a guest over, you'd have to show me that somehow they're seriously endangering others. I guess if you had a guest come over wearing a big sign saying I've contracted COVID-19 and, you know, I'm never going to wear a mask and I'm going to hang out in the hallway as much as I can and sing through this karaoke machine, especially as people are walking by, all right, then you're starting to endanger other tenants, and I guess that's a guest. And that, obviously that's a pretty absurd example, but maybe that's the kind of thing it takes to have that kind of argument where a landlord could limit the tenant's guests. Interesting questions. You're never sure which way they're going to go with some of these things, Eric.
Yeah, and I was going to post, because this is, I guess, at least partially related to this, is one of the other questions we get is just about amenities. So, which is, you know, kind of the same type of lease change that might occur if somebody was trying to.
Right. That amenities question is a big deal. You know, what should the landlord be doing to clean the place up between people going in and out? What's required? And hey, if they shut down a place, an amenity, do I get compensated for it? Which is one of those things that we've run into since the beginning and still see. Yeah.
All right. That's all the questions that, oh, one just popped up as I was clicking it away. Let's make sure I didn't lose anybody. Okay. Yeah, so another question, is offering a tenant cash for keys okay?
Yeah, I think so. I think a tenant can bargain to leave the place. And I have heard landlords, and I know that landlord lawyers have done this as well. It's not something that they go to first. There are a couple different types of cash for keys offers, just so we know what we're talking about here. The landlord goes over to the tenant and says, tenant, I know I can't evict you. I can't terminate your tenancy, but you owe me a bunch of rent. And I need to get somebody in here that's paying the rent. And here's what I'm willing to do. And let me tell you the types of things that landlords are offering tenants right now. Number one, I will wipe out your debt. I know that you owe me rent for the last 6 months, but I will wipe it out if you agree to leave by this day. Can you offer that? Sure, of course. And if you give me the keys and you leave, then I'll give you another $500. Those are real offers. Those are real numbers that I've heard landlords offering to tenants. Why? Because they want to get somebody in there that's paying and they have no idea when the tenant might actually leave. Because these moratoria, I mean to be pluralizing that, we really don't know when they're going to end. The CDC order was felt flippant on some levels, the way it was written and the way it was just sort of instituted almost immediately. Could be just as flippantly renewed and extended. The governor's moratorium, well, Michael Dahl talked last week about how close the vote has become at the state House of Representatives. I think that there's honestly a real chance in October that the peacetime emergency might end. I can't guarantee anybody that. Just because of the numbers, it's getting closer. The vote is getting closer in the House of Representatives, whether to take that power away from the governor. I think if it doesn't happen in October, though, the odds that it happens in November go down quite a bit because, well, we're going to have an election on November 3rd, and we'll find out who's going to be in charge of the Minnesota House, who's going to be in charge of the Minnesota Senate. I just think that during that sort of lame duck session, it's less likely that you'll see that vote happen, where the Minnesota House would vote to end the peacetime emergency. I might be wrong. It's not like we've ever lived through this political kind of questioned before with this sort of pandemic. So, and I'm not even sure I've ever shared that theory with anybody, much less just announcing it to a webinar full of folks. But yeah, I mean, elections change legislators' viewpoints, and there are different postures that they take at different times during their tenure in office. So I think the October one is probably the most pivotal one as far as the peacetime emergency goes. If it doesn't happen then, I'm not sure when it would happen that the legislature would vote to end the peacetime emergency. Again, Governor Walz can end it any time unilaterally, but he's shown no inclination to do that, going as far back as March 21st declared the peacetime emergency.
Yeah, I guess a reminder on this is that again, we're not going to be hosting a webinar next week, so nothing on October 7th, next Wednesday. The following Monday, the 12th, is the next end of the peacetime emergency. So it's likely, in the past few months, we've started to get word and public comments from the governor's office, a week or so leading up to that about their intention to extend. So I would assume you might start hearing about that in the news next week. And again, he'll have to, he's every time outside of the regular session, he has called a special session. There's been some questions about the necessity to actually do that legally, but he's done it. And so that's what we'd be looking for to happen on the 12th or before. And then on the 14th, so 2 weeks from today, that's when we'll have our next session. And so we'll be talking about what happened on the 12th and any issues related to that. And we may also have a special guest on, which we'll announce later, since we have 2 weeks to go until that time. So we did get some other questions. We're sort of open here, got another 10, 15 minutes. So if there are any questions, feel free to send them in. Did get a couple other sort of anonymous questions that came in all over the map here, but good questions. So somebody sent in a question about a universal rent voucher. Matthew Desmond, the researcher and author who's of the book Evicted, has put forward a national sort of proposal for a universal rent voucher. And the question is about the estimates that the U.S. Spends around $20 billion on the mortgage interest deduction, homeowner tax credit, and that a universal voucher would only be around $11 billion. I'm not sure if those are the numbers or not, but might have been a couple of years ago. That's what the estimates were. But I guess the question is getting submitted here is, how would a universal voucher system work that covered renters' income based on income, or would cover the rent based on their income? Would it be a third of their income? I think what I've heard is that, yeah, quite a bit of it has been, it's still sort of like just sort of a brainstorm of an idea, but that it would very likely mirror the Housing Choice Voucher Section 8 program.
Yeah, I mean, for all of my career, when people find out what I do for a living, people might say something like, "Hey, why do some people get their housing paid for? Why is it subsidized? Why do they get subsidized housing and I don't?" And my old boss, the guy who founded Homeline originally, Charlie Warner, was very fond of pointing out the largest housing subsidy in the United States, which is the mortgage interest deduction. That's it, which is not Section 8. It's not for renters. It's for homeowners that get a deduction on their mortgage interest. And you can say, well, of course they do. That's what is. And that's true. It's what is. That doesn't mean that that's the only option for where to spend dollars on or resources on how to subsidize housing. Because a lot of us have subsidized housing, whether we call it that or not, through that mortgage interest deduction. But anyhow, it's an intriguing thought. I'm not sure how it would mechanically work. That would be something that would be debated a lot, I'm sure. But yeah, the brainstorm, there's no harm in doing that. Sure.
Right. And My teenager is having trumpet practice right now, so apologies if you get that in the background. Okay, any other questions come in? Not seeing anything. What else here? Why couldn't we build, so another question submitted in advance, why couldn't we build a set of rules that allow cities and towns to use eminent domain in order to secure affordable housing or naturally occurring affordable housing properties? How can we help that no more of these properties will be lost to hands of developers or flippers? How else can we maintain and preserve these units as actually affordable? Yeah, I don't know a ton about eminent domain other than I think there's some pretty clear guidelines for what it can be used for. And I mean, in my history at Homeland, I've seen it actually be used to demolish affordable housing and replace it with probably not as affordable housing. So yeah, I think there's a lot of policy ideas out there for trying to preserve these units. And
yeah, eminent domain is one of those controversial topics. And you will find people on both sides of the political aisle that love it and hate it, and sometimes at the same time. Eminent domain, for instance, has been used to argue that the federal government has the power to seize land on the Mexican border in order to build a wall, which is mostly conservatives right now arguing that, who normally would rail against eminent domain. But they say, oh, it's as a public need or a public good that we're trying to meet. Railroads have used that historically to be able to put utility lines. And so is it possible that eminent domain could be used to sort of take over property? Well, sure, I think it's possible. And it's kind of what's happened on some level with some of the larger buildings where owners have tried to opt out of federal subsidies programs at points where maybe their contract gives them a window to do that, where a nonprofit will swoop in and essentially buy the building from the owner at something near a market rate, which isn't really eminent domain. It's not the public government doing it, but it's the same concept that the owner is made whole by getting market rate anyway. So why not sell it to somebody who's going to keep it as affordable housing? Eminent domain raises the specter of the concept that the government can just say, you'll either take this price or else you'll take this price. That's going to be your choices. And so it makes negotiating a lot harder, but negotiating certainly does happen with eminent domain. Oh, really? You want to go to court with me, government? Let's go do that. And I'll be all over the newspaper and in the social media and on the TV talking about how unfair this is, that you're stealing my property. And so those negotiations do happen. So I think eminent domain is a possibility for maintaining affordable housing, sure.
So then another question that's kind of down this lane a little bit is sort of in the same vein, are there other models for how residents might be able to quickly and efficiently organize and respond to the loss of affordable housing? And that there's some other cities that have done this around forming tenants, cooperatives and/or condo type situations. That's a good question. I think this actually is something that there are laws in place in other jurisdictions. Washington, D.C. in particular is one that has both rule on the books for both tenant opportunity and district opportunity to purchase. So protections in place for what I don't know all the details of it, but like when a building is potentially up for sale, tenants can organize and purchase the building, or in some cases, if they're unable to, the local government can help assist with that type of thing. Something that the city of Minneapolis, the city council actually is in the midst of considering over the past year. And my understanding is that there's actually a report, there was a study that the city contracted out to some organizations to do some research and investigation, and I think sort of some study groups of stakeholders in this area, specifically in Minneapolis, around this idea of providing renters more opportunity and power, regulatory power to purchase their building and turn it into a co-op or something like that. And my understanding is that the city, that study is going to actually get reported to the city council sometime within the next month. I can't remember the date, but if I remember where that is, I'll post it on our recording page after we put the recording of today's session up.
All right.
Right.
I see one last question about the lower rents in that grouping.
Oh yeah. Yeah. How can tenants negotiate to have rents go down from where they are now? Rents are too high for the working poor and they continue to rise. How could we actually negotiate to have rent go lower? Not through just the regular market process, but through some sort of common good or public good or a public process.
Well, that is an ambitious concept. So this is actually beyond rent control, actually, this question. This is saying we not only want to control the rent, we want to lower it as well. And I think rent control is a politically really Everest-like mountain. I'm not sure how viable that goal is. Maybe in some cities, certainly not statewide. There's a state law that makes it difficult to do as well, even at the city level. And so I'm not sure that rent controls or rent lowering is viable. Again, I will say we are seeing signs that rent is going down on some levels, right? At the very lowest levels, I'm not sure that rents are really going down. And I don't really know what the lowest levels of rent are in the metro area. It's going to be $800 or $900. That's about the floor for most rentals. And I'm not sure that those rents are going down. But the ones that were going for $2,000 a month last year might be going for $1,950 now or $1,900. The ones that were going for $1,500 might be going for $1,475 right now. We're actually seeing an inching down from rents from prior years, which is the first time we've seen that in my career since 1996. So the market is doing something. You might not think it's satisfying enough, and I understand that. But yeah, rent control or rent lowering, both politically charged issues for sure.
Yeah, and I did just post the link to the recording of our session in early September with Dan from Housing Link, where he had a series of slides, and the slides are on that page too. Where he went through some of the market trends that they're seeing from their perspective. They do a lot of data crunching and numbers with the listings that they have. So, all right. Well, I'm gonna go ahead and say we can close it up 2 minutes early here. And again, we did get a message from somebody saying they support having our webinars go to every other week. So that is what the plan is, at least for the next our next session will be 2 weeks away from today on Wednesday, October 14th. And we will send out some more information about what we plan to discuss and if there's going to be a guest speaker on that session later with the recording from today.
Yeah, and we thank those of you that have joined us almost on a weekly basis. Some of you watch this every week, and we really appreciate that. And we still have this core group of people that tunes in regularly every week. But we just decided it made sense to do this when we know there's new information, or we've got something planned that's a little bit bigger topic. So we will keep you posted, and thanks again.
Thank you, everybody. Have a good rest of your day. Goodbye.